Hello everyone, I'm Maureen Coleman, Professional Standards Advisor with the Real Estate Council. Welcome to Understanding the New Contract Assignment Requirements. This is a condensed version of the webinar that we presented last week, June 8 and 9, to managing brokers. And our purpose today is to give the benefit to managing brokers that weren't able to attend the webinars last week, and also licensees generally who want to find out more about understanding the new contract assignment requirements. So let's continue on. So the new contract requirement rules require that licensees who are providing real estate services, trading services on behalf of a buyer that does not want to have a contract that has the default language in it must present a notice to seller regarding assignment terms. Now the default language, will just articulate that up front, because through this webinar, rather than repeating the language in every instance, I'll refer to the default terms. So the default terms that are required, unless instructed otherwise by a buyer client, to be included in all contracts of purchase and sale are: A, this contract must not be assigned without the written consent of the seller, and B, the seller is entitled to any profit resulting from an assignment of the contract by the buyer or any subsequent assigner. So the regulation was brought in to help ensure that sellers' best interests are protected by injecting transparency into the real estate transaction in relation to assignment. It was found by the government that sellers were not aware that contracts are always assignable unless otherwise specified, and further that they could be assigned for a profit. So it was designed to prevent situations in which the buyer purchases a property only to reassign the contract at a higher price before the closing date without the seller's knowledge. The standards terms must be included by default in any offer, unless the client instructs otherwise. So as we alluded to earlier, it's intended to protect sellers' interest and deter potential licensee misconduct in relation to contract assignments. So let's look at what the opportunity is. What we always want to achieve is having informed and engaged consumers. And keeping that in mind, licensees have to be mindful always of who their clients are, and that it is the client that takes the decisions. The licensee advises as a trusted advisor with special expertise, but ultimately the client decides. The goal of this new regulation is to make sure that sellers are fully informed with respect to any assignment provision contained within a contract of purchase and sale. So as licensees and managing brokers and brokerages, we always have to be mindful that licensees have an obligation to run their business like a business. They're considered professionals, and as I alluded to before, trusted advisors with special expertise. So this new regulation gives an opportunity for licensees to fully put their mind to how can they best advise their clients. The regulation is enforcing the requirement that licensees have a discussion with their respective clients, buyer client or seller client, about the intricacies around assignments. Now, in many instances, I'm sure that's always happened, but the regulation is now going to require that. And in running your business like a business, whether you're a brokerage or an independent licensee, you have to apply the appropriate resources to make sure that you are fully informing and engaging your client so that they can make decisions that serve their best interests. So moving on to a little bit of history, you may recall that the Premier made an announcement on March the 18th, wherein she set out the goal of dealing with the question of assignments, sellers not being informed about assignments, and the allegations that licensees had misconducted themselves with respect to assignments. So the goal of the regulation is to strengthen the protection of sellers' interests with respect to assignments. It became effective May the 16th, 2016, and you can tell by the rapidity with which the regulation was brought into force, the government is taking it very seriously, as does the council. So the regulation is applicable to contracts entered into May 16, 2016 or later. And if negotiations were underway but not accepted by May 16, the regulation applies. Now at this point it's probably a good time to pause and emphasize that the regulations set out obligations on real estate licensees, on the buyer's agent to provide a copy of the notice to seller regarding assignment terms if the offer that they have drafted on behalf of a buyer client does not contain the default language with respect to the written consent or the seller's entitlement to profit, or if there has been an additional assignment term that varies the intent of the default language. So it applies to licensee. It is the licensee's obligation. The buyer agent and the seller's agents, their obligation is to have a discussion with the seller about the impact of any language relating to assignment. In fact, the regulation prescribes the areas of discussion that a seller's agent must have with their seller respecting assignments when a notice is delivered. And that is under section 8.2 bracket 7. So they've got to provide the notice, inform the seller whether the contract may be assigned, and if the contract may be assigned, about any conditions in the contract on the right of assignment, and about the seller's entitlement under the contract to any profit. So this regulation in no way impedes the ability of a buyer and seller to negotiate, but what it does ensure is that the seller is fully informed about any assignment conditions, first by the delivery of the notice to the seller by the buyer's agent, and second by the discussion with the seller's agent about the implications of the form. So the new assignment rules, the default clause is now included in BCREA standard contracts available on web forms. So those of you that are members of BCREA and use web forms, you will find it embedded in section 20A of the standard contracts of purchase and sale. So the language is there, so you are able to discuss that with your buyer clients in advance of drafting the offer, so they can put their mind to what the implications of the default language are to their interest and whether they need to be modified, varied, or struck. In that event, you would be providing a notice to the seller or the seller's agent. If you're not a BCREA member, I've talked to a number of commercial brokerages and their lawyers, and I understand generally that the templates that are being used by non-BCREA members are also being modified to address the obligations of licensees with respect to the regulations. So here's the form, and let's emphasize, if there is no circumstance under which your buyer client may want to assign the contract or add another party to the contract, the form is not required. If it's just a straightforward transaction where there is no likelihood of an assignment, no form is required. The form is only required to be delivered by the buyer's agent in the event that the default language is struck or varied. So the form's available on web forms if you're a BCREA member, or it's available on the council's website under our forms section. I'll mention one thing at this time. All of the information that's available to licensees on the council's website is also available to consumers. So you can direct your clients to anywhere on the council's website to obtain information if they have an interest. So just to touch on a couple of other elements that licensees have to keep in mind. There is one exemption in the regulation specifically for development units. So the regulation was brought into force to protect the interests of sellers in relation to assignments. Our understanding is that the government felt that developers were not requiring the degree of protection that a regular seller would. And typically developers have their own assignment clause that suit their purposes in their contracts that relate to their development units. So development units are described under Part 1 of the Real Estate Development Marketing Act. And so these regulations do not apply to development units. I've had a number of queries as to whether or not it applies to commercial real estate. And the regulation does apply to commercial real estate. So as I alluded to earlier, commercial brokerages that are not members of boards are needing to confer with their legal counsel to make sure that their contracts are compliant. And again, the obligation is that of the licensee, not the buyer and the seller. The buyer and seller are free to negotiate, but we want to ensure that that negotiation, and that's the purpose of the regulation, is in an informed negotiation. As a result of the new regulation, the council developed a form to assist licensees in making the disclosure. And that form is going to result in a rule change that is out for consultation at this time. It's believed that the change will come into force as of July 1. And that change to Section 8-4 of the Council rules describes general records. And this notice to sellers regarding assignment terms will now become a general record that licensees must provide to their brokerages, and brokerages must maintain a record of those forms and be able to produce them to council for review. Given the matter of the form becoming a general record, like all other general records, brokerages are going to have to develop systems for retaining and recording the forms. So as a suggestion, it would be likely that there would be an Excel spreadsheet that would retain the salient information on the form so that it could be searchable and produced if required. I would also make the suggestion that maintaining it as an electronic record would probably be practical. Let me give you a scenario. You have a licensee listing agent that is dealing with multiple offers, and more than one of the offers has a notice to seller regarding assignment terms form. It appears to me it would be practical for the listing agent to take a picture of each of the disclosure forms so that they could be forwarded to their brokerage in electronic form. So a licensee's responsibility, if they're a buyer's agent, is to ensure if the default language is struck out, altered, or a term inserted that varies the intention of the default language, they provide to the seller or the seller's agent with the offer a copy of the form. The brokerages, and subsequent to the offer being accepted or not, the licensee must provide the form to their brokerage as a general record. This obligation flows out of Council Rule 3-2 bracket A that says licensees must provide all general records to their brokerage. And then moving on to brokerage responsibilities, once the new rule comes into force on July 1, brokerages will be required to maintain copies of those disclosures as a general record. So, for example, if an offer is accepted, the brokerage would retain it in a deal file. If the form related to an offer that was not accepted, then the form would be maintained in a general file, and as I suggested before, perhaps on an Excel spreadsheet that would be searchable with the salient information on that spreadsheet. Now, I just wanted to touch on the most common questions that I've been asked regarding the regulation. And the first one is the most common. What if my buyer client wants to register a spouse or corporate entity? The second, what if I'm the listing agent and a buyer's agent presents me an offer that does not have the default clauses and has not provided the notice to sellers form? And finally, and I've touched on this already, will all brokerages have to complete, collect, and retain the notice to seller regarding assignment forms? So let's go on to question number one. What if my buyer client wants to register a spouse or corporate entity? Now, the first bullet you'll see is advise your client to obtain independent legal advice on how their offer may be structured to achieve their goals. And I know this is a point of frustration to licensees because it would be preferred that counsel would give a standard bit of advice. But the reality is the circumstances of each buyer and what they're trying to achieve may vary. So the one-size-fits-all answer is not appropriate. And I'd ask that as licensees you keep in mind you have an obligation to advise your clients to seek independent advice in any area outside of your expertise. So for example, you don't hesitate to recommend that they engage a mortgage broker or property inspector. And at the beginning of your relationship with a buyer-client, it would be prudent to have a consultation with them to find out what is going to be required. Are they going to want to sign the contract or register it into a corporate entity or the name of a spouse? If you have the conversation in advance, then there isn't that last-minute panic if a matter arises and they're writing an offer on a property. If you have the consultation in advance, you can go over all of the possibilities that may arise and have your client put their mind to it the same degree that you will put your mind to it. Again, a fully informed and engaged client is a client that's going to be much more satisfied with the process of the transaction. I think it's human nature for us to feel uncomfortable when matters get away from us and we haven't been able to contemplate them in a timely and prudent way. So a conversation up front with your buyer client. If they instruct you to alter the assignment terms, that triggers the requirement that you deliver a copy of the disclosure form to the seller or the seller's agent. And if you're not sure whether or not a term that you're including alters the intent of the default language or inserts a clause in addition to it that may impact the intent of the default language, then present the form. We're in the office at the council talking about when in doubt, fill it out. And it's very similar to, I know a lot of you operate on the principle of if in doubt, disclose. This is no different. So the second question is, what if the listing agent and a buyer's agent presents me an offer that does not have the default clauses and does not provide me with the notice to seller form? Well, in the first instance, as the seller's agent, ask the buyer's agent to provide the form. I'm going to make a suggestion, and this would be a transitional suggestion. It wouldn't be a bad idea as a seller's agent to have some blank copies of a form if you're doing offer presentations to your seller, just in the event that the buyer's agent somehow isn't aware of the new requirements or has made a simple mistake. That way you could present them with the form and say, would you mind filling this out in order to comply with your obligations under the new regulations? If they refuse to do so, you should bring the matter to the attention of your managing broker, and your managing broker in turn should bring the matter to the attention of the council. Additionally, I'd suggest that if I was a managing broker, I would appreciate a call from another managing broker if my licensee was not conducting themselves in compliance with this regulation or any other aspect of the Real Estate Services Act regulations or council rules. A phone call like that can go a long way to ensuring that everyone is contributing to raising the standard of practice. If there is no form, you would, of course, advise your seller that the offer doesn't include or alters a standard assignment term, that the buyer's licensee has not provided it as required under the regulations, and whether or not the proposed contract as written may be assigned. And if the proposed contract may be assigned, any conditions in the contract of the right of assignment and the seller's entitlement to profit resulting from the assignment. Now keep in mind the standard language not only speaks to the seller's entitlement to profit if the contract is assigned, it also speaks to any subsequent assignee. So you can understand that this is a fairly complicated matter. The regulation does not define profit. And our understanding is that the question of profit is a negotiation between the buyer and the seller in the event that the buyer is looking for the seller's permission to assign a contract. So again, this is a discussion that you would want to have with your seller if, for example, a buyer subsequently came and sought advice, sought permission to assign the contract. At that stage, you would probably want to recommend that your seller get legal advice so that the question of profit and anything that might accrue to the seller could be established before the seller agreed to any variance on the terms. So after this discussion, of course, the seller can instruct you on how they wish to proceed. Once again, you advise, but your client decides. Now the third question, mainly for managing brokers, will all brokerages have to complete, collect, and retain the notice to seller regarding assignment terms form? And the answer is yes. Any managing broker or their designates whose licensees have been involved in an offer where the form has been required and presented with the offer must fill out the brokerage use only. So let's be very clear. Both the buyer's agent's brokerage and the seller's agent's brokerage need to have a copy of the disclosure form, and each respective brokerage would fill out the brokerage use only section. And again, as I've suggested, licensees can use their electronic devices to ensure that the general record, which is captured, the disclosure form is captured by, gets to the brokerage. So where the offer has been accepted, and we've touched on this earlier, the form should be kept in the related deal file. Forms involved in offers that were not accepted should be retained in a general file, and a listing of those maintained in an Excel spreadsheet or whatever other program you typically use in your brokerage. So let's just recap right now. The goal of the regulation was to ensure that licensees are dealing with informed and engaged consumers. An informed and engaged consumer is a well-protected consumer. And that is the entire thrust behind this regulation. So it's an opportunity for licensees to ensure, and I know many do, that they have conversations at the outset with their buyer clients and seller clients about all of the processes and all of the questions that arise through a negotiation for a trade in real estate. That's the goal, and we're sure that we're going to be able to achieve it through this new regulation. So on that, I want to demonstrate to you some of the resources that are available to you as licensees and also to your clients and other consumers on the council's website that assists you in fulfilling all of your obligations to your clients. So most of you are going to be familiar with the council website. And when I was speaking with the managing brokers the other day on the webinars, I pointed out that as experienced managing brokers, they know as much as I do as a professional standards advisor. But because of my role and the fact that I work on the council's website every day, I'm sometimes able to find the answers more quickly. And so my role is to be a resource for consumers and for managing brokers and for licensees when their managing broker isn't able to assist them or if they can't find the information on the website. So we invite consumers, managing brokers, and licensees to engage with the council. And what you'll see on our website is a ton of information, and the more familiar you get with the website, the more easily you'll come to navigate it. But I'll point out in particular the Professional Standards Manual. Now this is now, and has been for the last couple of years, word searchable. And the nice thing is if you go into the search bar and put in new regulation or contract assignments, it'll search not only the Professional Standards Manual, but also the Brokerage Standards Manual and the reports from council, where we write articles which are often then inserted into the Professional Standards Manual. So anything that we've said, typically you'll find it here. We also have FAQs, and in particular our legal department has worked out a great number of scenarios in relation to the new restriction on contract assignments and developed FAQs to that to answer licensees' questions. So you can go to that anytime, and I would suggest after this presentation, if you've got any doubts, go to the FAQs, and if you come up with a scenario that we haven't contemplated, we'd really like to hear about it, because we're trying to develop as much information as possible to assist consumers and licensees in understanding the application of the new regulation. So when you go to the FAQs, as I mentioned, we've really worked hard on developing the scenarios, and I think you'll find it quite useful. So some general information, guidelines, guidance for buyer's agents, seller's agents, and general information, fairly exhaustive. So as I said, if you come up with a new scenario, by all means let us know. That would be something that would be useful. And as being a self-regulating industry, it's really important that you contribute as to your abilities to help the council fulfill their role, the mandate of public protection. So we also have the forms I mentioned earlier for BCREA members. The disclosure form is in web forms. Additionally, it's available on the council's website under disclosure forms and notice to seller regarding assignment terms. Now, this is a constricted copy of the notice to seller. It doesn't have the information about assignments on it. But just to point out to you, Part A is filled out by the buyer's agent who is presenting the form to a seller or a seller's agent in relation to a contract where the default language has been struck or altered, or a new term that impacts the default language in Section 20A. So the notice to the seller, the address of the property, the name of the licensee, legal description, and date of notice provided. This would be the information that, in addition to the form itself, that a brokerage would want to include in a list that they're going to maintain of these records. Part B is where the seller is asked to sign the form and acknowledge the date on which it's received. Now, I'll just touch on this right now. If a seller declines to sign a form for whatever reason, the council's expectation is that the seller's agent will use best efforts to have the form signed. But if the seller doesn't want to sign it, the seller doesn't have to sign it. But just as in any other circumstance where something unusual comes up, we'd recommend that a licensee makes a note to file that they requested that the seller sign the form. The seller declined to sign the form, but a copy is still provided to the respective brokerages of the buyer's agent and the seller's agent. And then the third box is brokerage use only. The listing agent, the seller's agent's brokerage would fill that out on the copy that they have provided to their brokerage, and the buyer's agent's brokerage would fill out the form that had been provided by the buyer's agent. So each each brokerage has a copy of the form, and the form is filled out by the respective brokerages. Now, I'm sure that there's questions that have not been answered, but as I referenced earlier, I would encourage you to review the FAQs on the Council's website. And if there's any questions that aren't answered there, by all means, let us know. If you've got uncertainty, you might want to speak with your managing broker, and if you jointly have uncertainty, don't hesitate to get in touch with me at the Council. And my contact details are there on the screen, and I do very much appreciate you taking the time to participate in this webinar. Thank you.